Howdy folks, welcome to yet another edition of Smarter Money Matters with me, the Wealth Doctor, Jeff Camarda, joined by super CFPs, Anna Wunderlich and Lou Versil. So I think you're really going to get a lot out of today's episode, which we've entitled True Wealth Tales of the Wealthy, a Money Makeover Fixing Major Mistakes, number 1. And we'll be doing additional case studies like this. This is from an actual fact pattern for some folks that actually became clients of Camarda Wealth. Of course, we've anonymized the data, but what we thought we'd do is kind of tell you, almost like on the CFP exam question, what the fact pattern is, what we learned in talking to these folks, and what the best practices that we recommended in order for them to correct some mistakes and improve their wealth. So in this episode of True Wealth Tales, we uncover the biggest money mistakes that this particular wealthy couple made, and how a money makeover can really help them fix them. So you learn as you go through this very powerful wealth management strategies and financial advisor tips to avoid common money mistakes and help protect your wealth. So let's begin by telling you a little bit about the folks. Of course, we've changed your names. Anna, do you want to start?
Sure. So the clients in this case are Kathleen Brown. She's born on February 12th, 1956. And her husband, Thomas Brown. He was born February 21st, 1952. And they reside locally at 123 Side Street.
Kathy is she's retired, but she continues to work part-time as a scientific consultant and analyst, generating about $70,000 in 1099 income, and she feels like she's paying, as most of us do, too much in income taxes. Her private practice is filed taxes as an S corporation. She's planning to fully retire at age 70 and start collecting Social Security benefits at that time. Her husband Thomas is retired, and actually retired when he reached his full retirement age at age 67 from Social Security, and currently is collecting $3,500 a month from Social Security. They have named each other as primary beneficiaries, as most couples do, with their children, Christine and James, designated as contingent beneficiaries.
Very good. So the Browns, they also feel that between their combined Social Security income and $2,000 a month that Tom is receiving from in his pension, that should be enough to kind of last them throughout retirement and make them live comfortably.
They've considered establishing a trust for years, but they haven't taken this step. And they're very concerned about protecting their assets from court charging orders and creditors. In addition to retirement and estate planning, this is one of their top priorities. Tom was actually recently involved in a car accident.
Oh, no.
He ran a red light and he T-boned another driver. They had a $1 million umbrella policy, but after the accident, they are concerned that this is maybe not enough protection and want to review other options.
And as we get into the case, you're going to see that's a very legitimate concern that probably many of you share. So the Browns maintain a net worth of approximately $3 million, according to them. Kathy's investment portfolio consists of a brokerage account that's valued at $70,000 with a major bank. She's got a traditional IRA at a major brokerage firm worth $500,000, a Roth IRA at another brokerage valued at $300,000. Husband Thomas has 2 brokerage accounts, one that was inherited from his parents worth about $1.2 million, at another money manager, and another at the same money manager that's valued at $350,000.
Very good. So and they're on a primary residence that is jointly titled, and that's worth about $700,000. They just recently, last month, they paid off their mortgage, so congratulations to them on that. They're currently working with a CPA for their taxes, and they were very happy with that arrangement. And they found us actually through Smart Advisor.
Which is an advisor referral service.
Correct.
Right?
They read an article online that talked about fiduciary advisors, and they realized that the advisor they're currently working with may have been what Jeff calls a two-hat advisor. So I'm sure he'll expand on that. As we kind of continue.
And that's enough of a pack pattern. So let's see what I mean by two-hat advisors, which is a term that I came up with in my academic research. Basically means that the United States investment industry is really segregated into two distinct industries. Number one are broker-dealers whose basic business function is to sell product on a commission or markup basis, like a car dealer, broker-dealer, same basic concept. The others are fiduciary advisors, like Camarda, that are regulated by a different congressional act, and fee-only advisors like us don't make anything off investment recommendations. We just charge a fee like an attorney would in order to render advice without having any particular interest in a particular investment other than it's best for the client. So we have a lot of advisors, a significant percentage of advisors have both licenses. They have commission brokerage licenses, one hat, and they have fiduciary fee licenses, the other hat. So if they have both licenses, we call them two-hat advisors, which can be kind of confusing and misleading for a lot of consumers. So the first thing that we noticed is they have a number of brokerage accounts that are, many of them are, one is with actually two are with a fiduciary advisor, but the others are with two-hat advisors, right?
Correct.
So where there are commissions and maybe some underlying costs, and we recommended a portfolio stress test, which we think is indicated based on potential exposure to at least one non-fiduciary advisor. And some other potential concerns, as we see quite frequently, are more aggressive investment holdings, more risk than they may be comfortable with, which may not be downside controlled if we see another market cataclysm, as seems to happen, predictably throughout history. And hence, we suggest that they may be exposed to significant losses from which they may not have time to recover, particularly at an important turning point in their life, just as they're on the cusp of retirement. Kathy's about to hang it up completely in a couple of years, so they're going to need to have these resources work for the rest of their life. Now, Lou, I know you made a number of observations about the income tax flaws and some ways to improve it. You want to expand on that?
Yeah, sure. So Kathy currently, like we said, she continues to work, and she's bringing in about $70,000 a year. Now she has a S corp, and she's getting she's actually taking all the money from the S corp and paying herself as a W-2 income, the entire $70,000 that she makes in a year. So one of the strategies that we notice and we advise on is that she could potentially pay yourself what we call a reasonable earned salary, like a reasonable wage, and possibly reduce her FICA tax that way.
Well, definitely, and this is a common error, and we see a lot of tax opportunities for improvement. But if you own an S corporation, you're required to pay yourself what the IRS calls reasonable compensation. So if I work in an S corp, say the S corp is making $300,000 a year, and I could hire a manager to do what I do in the corporation for $70,000 a year, right? So we have the $70,000 compensation for what I do in the corporation, and then the other $230,000 is profit. But if I take that entire profit, as Kathy is in this case, as W-2 compensation, not only am I paying the income tax and all of that, I'm also paying the payroll taxes, Social Security and Medicare and some other stuff, which is an additional burden on top of the income taxes. And Lou's point is, just take a reasonable wage or reasonable compensation out, and the rest of that will be paid to you basically as a dividend from the company that you own, but you won't be subject to payroll taxes, right? And I think you also mentioned that we're not concerned about estate taxes in their case because their net worth probably won't get to the threshold during their lifetimes. I know, Anna, you had a lot of observations about asset protection opportunities, particularly with the complexity of the inherited account. Would you like to expand on that?
Yeah, so in their case, right, they have over $1.6 million in taxable accounts, brokerage accounts that are exposed to a creditor or to a lawsuit, right? The way they're sitting, if they're sued, those are accessible accounts to a charging order. So a simple way that they could resolve that issue is to establish LLCs that are charging order protected. So they would work with a lawyer to set those up properly to protect those assets in case of a lawsuit. They could also raise their umbrella policy to maybe 2 to 3 million, higher limit, to protect as well. On top of that, with Thomas's 1.2 million that he inherited from his parents, there are some concerns there with that being a marital asset. Or not being a marital asset in case of divorce, meaning it came from his parents, not from their marriage. So there could be some value in having a separate LLC for those funds as well.
Yeah, so keeping that separate, they're probably not concerned about divorce risk at this point in their lives, but you never know. You got to ask them. And if you inherit money or have it before the marriage, in most states that's not considered to be marital property, so it's off the table for a divorce split. But if he would have put that in joint names with his wife, then it becomes marital property. He's basically making a gift of half of it to her. But the LLC thing is also, you got to be really careful. Asset protection is something we think is really, really important. And the point that Ann, to underscore the point she was making, some accounts, IRAs and 401ks are typically protected. Your home is protected strongly in Florida and varying protection in other states. But non-qualified accounts, it's taxable accounts that are just in your name, are typically not protected. So if somebody sues you and they get a judgment for $10 million and you have a $2 million umbrella and the umbrella pays, and it may not, but say it does in this example, but you hit a football player who's now going to be out millions of dollars, the judge says you've harmed them $10 million, you're still on the hook for the other $8 million. And if there's $2 million in brokerage accounts or non-qualified accounts that are not otherwise protected, you just kind of low-hanging fruit, pay up. And Anna's recommendation of using properly structured LLCs, and they've got to be properly structured. We see a lot of LLCs that weren't done what the law requires, and they're really useless as asset protection vehicles. But properly structured LLCs make assets within them pretty much bulletproof. They said if a charging order protected, judge issues the charging order, but it's protected from the charging order because of its nature, and it's a very powerful asset protection device. Lou, I know that you looked at their life insurance situation, and what was your conclusion there?
So they're up there in age, so to speak. Their retirement age, they're close to 70. I know. Huh? But as we know, life insurance gets more expensive as we age, as we get older, and they don't have a lot in terms of liabilities right now. So it's probably not the best time to be shopping for life insurance at this time.
Yeah, I don't think they need it, because if you look at, they figured a net worth was what, $3 million?
Yeah.
So if one of them, and they both have Social Security, one of them checks out, probably him, sex and gender, and age are not on his side, but there should be plenty of money for the survivor to live on.
Correct.
And that's, my view on life insurance is that if you've got, you need to get cheap term insurance during a period where if a breadwinner dies, it's going to have a significant impact on a family. It's meant to replace that, but once you have enough assets to realize your financial goals, whether it's one or two of you, probably isn't a good idea.
Yeah, and we're not just going to assume that they don't need it. We're going to actually, Anna and I are going to run a Money Guy Pro retirement planning software and just kind of put all their expenses and the money that they have on the side and see how it all.
Yeah, we do a rigorous analysis, but on the surface it doesn't look like they need any.
Correct.
From an estate planning standpoint, though, by goodness, they need some estate planning, don't they?
Absolutely. And right now, they don't have any type of legal documents, estate planning documents in place. And like Anna pointed earlier, they have quite a bit of money that is in that's a probatable assets. So it would go through probate, which is a slow process. It can take sometimes years to get through. It's expensive. I know in Florida, if it's for $1 million, it's about $50,000 in probate costs that you can incur. So we would suggest, in order to avoid that, to kind of resolve that issue, is to definitely look into a joint trust, doing a trust, and then also doing appropriate powers of attorney documents to solve that issue as well.
Yeah, for healthcare surrogate, to make decisions, health decisions if you can't, and living will and like that. So I'm not sure if I call this, a common money mistake or a bad money habit or something like that. But we find a lot of folks that, they kind of know they need to do estate planning, but they typically don't get around to it. It's really relatively simple. These folks have a very simple estate planning problem to solve. Setting up a joint revocable trust They can take money, put money in, take money out. It's revocable. They can change the trust. It really functions kind of as a, I've had one for decades, and it's invisible. It's like having a joint account. You have checkbooks and a trust name, whatever. And then transfer the assets, like those non-qualified accounts, like those brokerage accounts, and maybe we set up the LLCs, put the brokerage accounts in the LLC as the safe box around it in case it gets sued, and then the LLC is owned by the joint trust.
Correct.
And this avoids probate, and also avoids guardianship, which we'll talk about in a second, and does some other pretty cool things too, right? So what if they get to the point down the road where they're not able to manage their affairs? We'll talk about guardianship now. They can appoint one of their kids as a successor trustee, to pick out the caregiver and to pay the bills and make investment decisions to keep things going, right?
Oh, absolutely.
After that, what happens is you're maybe exposed to guardianship, which is a court proceeding, which is just, it's expensive, it's demeaning, it takes a long time, it's really a stone axe of a planning technique. It's not even a planning technique, it's just what happens if you don't do any planning. So you don't want to expose yourself to guardianship, and a joint trust will help you to avoid that.
And the judge can pick a random person to be the guardian, right? Doesn't have to be someone.
Yeah, so so if say that poor old doddering old Dr. Camarda here hasn't done any planning, and I'm sitting on some assets, but I don't remember my name anymore, and this is my good son Lou, and Lou wasn't able to convince me to do any planning, so now Lou has got to take me by the wheelchair, and set a petition in guardianship court, and argue in my presence, and I still hear a few things, Lou. What do you mean I don't know what I'm doing anymore? Prove, that I am incompetent, and then the judge will appoint a guardian to manage my affairs and to have the checkbook. And it doesn't have to be my son Lou, the brilliant attorney. It can be the judge's fishing buddy. The judge has complete discretion in that. So it's not a good way to go.
Right.
The trust makes this really, really easy. And one of our recommendations is, for a trust to be as elegant and as efficient as possible, that the trust be the primary control device for all your assets. So what does that mean? What else? And there are some things we can't put in a trust, right, Anna? What's one of the obvious ones?
Yeah, I mean, you can't, necessarily put title or retirement account in the trust.
Yeah, IRAs, you can't, right?
You can't, but you can have the trust as, a beneficiary, whether they're primary or contingent on those accounts, so that the assets flow into the trust. Maybe property that you can't title in the trust, you can use a pour-over will, essentially, that says if it ends up, in probate, that it goes into the trust and then is administered following the trust and what the couple outlined when they did the planning.
But let's stay on that beneficiary thing, because that's a really important point. They have, like a lot of folks, who have a lot of money in their IRAs, and as she says, the only way to get the IRA money to the trust is take a fully taxable distribution and put what's left in the trust. You don't want to do that. If you got $1 million in an IRA, top bracket is going to like 40%. It'll cost you $400,000. You don't want to do it all in 1 year. But you can, using the right beneficiary language and provisions in a trust, make the trust the beneficiary of the IRA. So what happens now is Anna dies, prematurely, unfortunately. The $1 million goes into the trust, and the trust is the mechanism that determines, does brother get some, does husband get some, the kids get some, whatever it is that's important to her. So it's one consistent distribution device. You have to have special language in trust, by the way. What is that called? Do you remember?
We call that flex provision. Or
yeah, flexible spending provisions, and that's to.
It basically extends the that time that the beneficiary has to take that money out. Instead of 1 year, he stretches it out into 10-year period, and then they can pick and choose if there's a beneficial year when maybe they have lower income or something like that, where they can take more money out. They can they have the flexibility to do that.
Yeah, but if you don't have if the lawyer doesn't put that secret sauce in there, and a lot of times they don't. Then the taxes are not optimized, and they're all payable, and basically when you die, as soon as the money goes in the trust, you got to pay tax on a whole $1 million. You can avoid that with the right provisions there, and I think get a lifetime stretch for the spouse.
Yes.
So use that as it just simplifies things quite a bit. Any other points that you guys, and we've gone through this case, extensively this week. Any other points that you think are worth mentioning to folks out there?
I think one thing that we didn't talk about was their principal residence, and how in Florida at least, there's something called ladybird deed that can be.
I'm sorry, go ahead.
No, basically it allows your principal residence, your home, to pass to your beneficiaries outside of probate if you use that deed.
Yeah, so basically what that means is it's kind of like putting a beneficiary designation on the house. But we don't want to go to trouble, and in some states it doesn't make sense, to title the house directly in the trust, the primary residence. Investment property, I think, should be in a trust. Primary residence in a trust. What the ladybird deed does is basically functions like a pay on death account. Is like when the last of the couple are gone, it transfers the house into the trust, and the trust manages the disposition without having to go for probate.
Correct.
Right.
It does that, and
That's
also it's also beneficial for folks that are that qualify for Medicaid in the future. Their primary residence wouldn't count as assets against their qualification for Medicaid. So.
Good. So, any other afterthoughts from you, Ms. Wunderlich?
I don't think so. I think we covered a lot of the key points we uncovered.
Well, good. And this was, there's probably a lot of really good, financial planning and financial advisory tips that you picked up from this one. And we have a lot of these cases. And in future, we're not going to obviously get boring if we did it every week. But you'll get additional tales to the true wealth tales. From the wealthy going forward with different fact patterns, and some of them will be more complicated. This was a relatively simple case, although I'm sure it didn't sound that way to you guys, but that's why we think we're so good. But really, continue to watch for wealth creation tips, to maintain a wealthy lifestyle. We'll talk about investment mistakes to avoid, other aspects of personal finance makeovers and lessons from the wealthy that we have learned ourselves. And advise our clients on, and just general solid wealth management advice. If you have questions, we encourage you to email them to us, or gee whiz, if you even like to be on the show sometime, we'd be happy to arrange a call-in link. But go ahead and email us at smartermoneymatters.com. And Megan will put an email address in there for questions at smartermoneymatters.com or something like that. And we'd be very overjoyed to go ahead and give your specific questions a very thorough analysis and advice. So that's it for now. From Anna and Lou and me, Jeff Camarda. Thank you so much for watching this edition of Smarter Money Matters. Until next week, get and stay wealthy, guys.